and in the EAT in Woodhouse, which had suggested that there was a criterion of exceptionality before the separation argument could be accepted. Mr. Justice Lewis in Panayotou had said that he didn't think there was a requirement of exceptionality. Picking up 3 lines after the F at page 368, your Lordship will see, or your Lordship and my ladies will see, circumstances in Martin were exceptional. So saying that the circumstances in Martin were exceptional, and that if it was followed indiscriminately where complainants acted in an irrational way, it would undermine the protections provided to the anti-victimisation provisions. I agree with him that it is important that should not occur, but I do not, with respect, believe that it is necessary to go beyond what I said in paragraphs 22 and 23 of my judgment in Martin as quoted above. As I say, their employment tribunals can be trusted to recognise the circumstances in which the distinction there described can be properly applied, and I do not believe that it is useful to apply a requirement that those circumstances be exceptional. I note that Mr. Justice Lewis made the same point in Panayotou, see paragraph 54 of his judgment. That in the respondent's respectful submission is not only entirely accurate guidance, but respectfully we submit it is the best guidance which humanly can be given, recognising the myriad of potential factual considerations which will apply in every separability case. The court doesn't say this, but if I might summarise the guidance this way, it tells tribunals, you're entering territory where angels fear to tread, and be careful when you do so, and look at the evidence critically and carefully. However, it's up to you to decide whether the separability argument is appropriate or not. And that, in my respectful submission, is the essence of the separability principle. Now, 2 observations I make to address concerns that were raised in submissions by my learned friends, namely that raises the difficulty of unpredictability. Well, yes it does, but the reality is unpredictability is quite simply unavoidable in this context. The second observation I would make is it recognises the fundamental statutory function which is entrusted to employment tribunals. It is they who are the finders of fact. It is they who are required to deal with very, very complicated and complex issues about motivation. And in circumstances where their judgment is coherent, is reasoned, and is not internally contradictory, in my submission, their judgment should be respected. And there always remains the power of this court to intervene, or the Employment Appeal Tribunal, to intervene in circumstances where a judgment could properly be said to be perverse. But absent perversity, so long as the tribunal, in my submission, correctly directs itself in law, has regards to the evidence, holds it up, to borrow the phrase of His Honour Judge Auerbach, to the light, and reaches a logically defensible conclusion, in my respectful submission, there's no warrant for this court to interfere. Now, my lords, my ladies, there's been an attempt on the part of both parties to suggest that looking at previously decided cases in the whistleblowing context or in the wider context of, to borrow the phrase used by both my learned friends, retaliation, that in some way a guiding principle can be extracted, and that you can look at the particular circumstances of one case and say, arising from this particular circumstance demonstrates, because it was either upheld or overturned on appeal, the proper scope of the separability doctrine. Our respectful submission is that that's an inaccurate analysis. Because what are all of these decisions? They are simply indications or examples of the application of a principle. And subject to review by traditional failure to direct self-appropriate in law, failure to give adequate reasons or perversity, they remain simply that, examples of the application of a principle rather than indicia which constrain the scope of that principle. Now, my Lord, I'm conscious that my learned friends haven't engaged in a lengthy exercise of addressing the facts of various authorities, and I don't propose to buck that trend, as it were. But it does strike me that it might be helpful if we look at 2, potentially 3 whistleblowing authorities, to look at the court's approach in that regard, and why I say that the structured decision-making approach advocated by my learned friends, or particularly by my learned friend Mr. Laddie, is not one which is supported by authority. So, if I may, I'd like to start with Bolton and Evans, which is at tab 7 in the authorities bundle. The facts can be lifted in...
Sorry, can you give the page number? I'm so sorry.
No,
I'm on the electronic bundle.
I'm so sorry, my lady, it's page 86. Does your ladyship have that? I'm very much obliged. So, at paragraph 7, the Employment Tribunal found, at paragraph 63, that the claimant had made a public interest disclosure. It then turned to what it described as the issue of causation. The Tribunal appears to have accepted that the school's motivation for dismissing the claimant was indeed his conduct in entering the system in the way that he did, but it held that that was part and parcel of his protected disclosure. And my lord, my ladies, you'll have seen that in the authority there's discussion about whether the term hacking was strictly correct or not. But certainly there was an unauthorised access to the computer system. Moving on to paragraph 18, which is page 91 in the authorities bundle, we see, again in my respectful submission, useful indicia or useful indicators as to the proper approach to the separability principle. But even assuming, contrary to what is said in paragraph 17, that the claimant's whole course of conduct should be regarded as a continuing act of disclosure, the school's reason for the warning, as found by the tribunal, was its belief that the claimant had at the same time committed an act of misconduct. That was, in the terms of section 103A, the reason, or if more than one, the principal reason for what turned into a constructive dismissal. While I agree that the tribunal should look with care at arguments that say that the dismissal was because of acts related to the disclosure rather than because of the disclosure itself, in this case, there is no reason to attribute ulterior motives to the employer. Although not seized of this point, the Employment Appeal Tribunal made observations that are very pertinent to it in paragraph 62 of its determination. In this case, the employee had not been subject to any disciplinary proceedings when he had forcibly expressed views about the security system that should be adopted. Nor is there any reason to suppose that he would have been disciplined if he'd simply informed the school that someone else had hacked into the system. The employers acted because of their belief that it was irresponsible, and I emphasise that it was irresponsible for him to have done so, even if the purpose was to demonstrate the force of his concerns. We were urged to look at the whole of the claimant's activities, not just at his verbal encounters with Mr. Edmondson and Booker. If that is done, it becomes plain, as both tribunals found below, that the warning was given for the claimant's irresponsible conduct and not for telling his employers by whatever means that their system was insecure. Points I would seek to list or lift from that analysis, my lords, my ladies, are these. A need to look at the whole of the activities. A statement that the height of the claimant's wrongdoing was irresponsible, and certainly not, to borrow the words advanced by Protect in its written submission, wholly unreasonable or serious misconduct. And most importantly, what the appellate courts accepted was that whilst the Employment Tribunal had said that the act of hacking was part and parcel of the disclosure, when one actually looked at the reasons of the tribunal itself, the reason was because of his unauthorised access to the system. So rather, in my respectful submission, than suggesting that, rather than the effect of Bolton being to suggest it's really got to be something extremely unreasonable or, my summary, beyond the pale, in order for the separability argument to succeed, the Court of Appeal didn't make any pronouncement of that nature whatsoever. The height...
Well, sorry, Mr. Siddle, you're relying on a label, but what happened here was a hacking into an unauthorised hacking into a computer system. And that is the most serious misconduct, isn't it?
Well, my lady...
The label may
forgive me.
be irresponsible behaviour, but the quality of the conduct is serious.
Well, my response to that, my lady, would be, firstly, the label was irresponsible, but certainly there's no suggestion in the authority that there is, as it were, a threshold test that you need to transcend mere irresponsibility and you need to be in the realms of wholly unreasonable or serious misconduct. That's the first point. The second point is, whilst this, if I were to accept your ladyship's point, even though this was a serious incident, what that doesn't mean is that it's only in circumstances where it's an extremely serious incident that the separability argument can be accepted. So I fall back on my previous observation that this is merely an example of the application of the principle, and it doesn't constrain its precise boundaries.
But also, it's more than just a label, potentially, because that's how it's categorised by the court which is analysing it.
My lady, yes. And so, I say, with no disrespect to my lady, Lady Justice Simler, I say this. Number one, the court categorised it as irresponsible and felt that the separability argument was a valid argument in those circumstances. But in any event, I fall back, as I say, on my earlier observation, that this is merely an example of the application of the principle. It doesn't define the principle or constrain it. The next authority to which I'd seek to direct the court is the decision in Fessett, which is at tab 11, page 151, for those working electronically. I hope the court will forgive me. I need to look at the facts in Fessett in a small degree of detail in order to understand the arguments that were advanced below and as we'll see, the Court of Appeal's rejection of them. Points to be made by way of opening are, as one will see at page 153, this was a case where public concern at work, as it then was, now Protect, intervened in order to discuss the proper scope of whistleblowing protection. And the essential factual background, which I can demonstrate by reference to the paragraphs of the judgment if it would be helpful, but I hope to take it as a not unfair summary, and I'm sure my learned friends will intervene if my summary is in any way unfair, is that a number of individuals, including Mrs. Fessett, made protected disclosures as regards their view that a colleague of theirs, Mr. Swift, was claiming to be more qualified than in fact he was. It was found by the tribunal that those disclosures were entirely properly made and indeed in substance were correct. What then happened was that there's a description that the whistleblowers, as I'll describe them, weren't satisfied by the fact that Mr. Swift continued to be allowed to work in the walk-in centre in Wythenshawe in Manchester and continued to press their concerns. And the judgment refers to the effect of this being that the workplace descended into three groups. And we'll see that at page 155, paragraph 12. The claimants were not satisfied with this response and sought to pursue the matter further. This caused certain dissatisfaction amongst some of their colleagues, who considered that they were subjecting Mr. Swift to a witch hunt. The workforce divided into three groups: those supporting Mr. Swift, those siding with the claimants, and those who did not wish to take sides. It's also right to say that the tribunal were critical of the management's response to that situation, and that is seen in a number of places, but paragraph 18 at page 156 is an example thereof. Here we see all the claimants lodged grievances, although only that of Mrs. Hughes was ultimately pursued to a hearing. Her grievance was heard by Mrs. Nixon, who found that Mrs. Hughes had been subjected to treatment which had resulted in her being isolated and prejudiced. She also considered that management could have done more to prevent this. Although Mrs. Nixon made no findings with respect to the two other claimants, the tribunal was satisfied that had she done so, she would have reached the same conclusion about management's failings. The tribunal concurred in that analysis. So, what then happens is that as a result of the dysfunctional working situation, the employer acts to resolve it and transfers the whistleblowers from their place of work, as opposed to those who had subjected them to detriment, or those, or indeed anyone else. And the point was taken that this was plainly detrimental treatment by reason of the protected disclosures which had been made by the various individuals. So that is the factual context, and it's important that we look at the tribunal's finding as regards the reason for the redeployment. That's at page 158, paragraph 24. And again we see, the tribunal then focused on the positive acts of the employer and concluded that neither Mrs. Fessett nor Mrs. Woodcock had been redeployed away from Wythenshawe because they had made a protected disclosure. Equally, when the decision was made by management to redeploy Mrs. Fessett and Mrs. Woodcock in June 2008 away from the Wythenshawe Walk-in Centre, this was because the situation at the centre had rendered it dysfunctional, such that their removal appeared to management to be the only feasible means of resolving the problem. It was not done because the claimants had made protected disclosures, and was therefore not done on the ground that such protected disclosures had been made. So, rather like I would say on the facts of this case, a scenario which flows from and is closely connected to a protected disclosure, but the tribunal accepted that as a matter of fact, the protected disclosure was the context to the reason rather than being the reason itself. And may I briefly now, because it strikes me it's the appropriate time to do so, deal with Mr. Young's attempt to suggest that in some way Fessett is...
Sorry to interrupt, Mr. Simler. It's so difficult when I'm on the screen.
Not at all. Not at all, Malone.
There was additional conduct here, wasn't there? Because the whistleblowers didn't accept the fact that there'd been grievance,
They weren't, but your ladyship is quite right.
They didn't accept that they pursued a grievance, and they wouldn't accept what management had done.
What they did was, the finding is that they raised a further grievance because they weren't satisfied that, despite the fact that their complaints were upheld, that Mr. Swift was able to continue to provide care. So your ladyship is right. Yes.
Exactly. So I'm just trying to understand, what is the separate conduct in our case?
Well, if I may, my lady, it strikes me that the time to address that is when I've gone through the various factual findings. I'm conscious that forgive me. I'm conscious it's something I need to address and I propose to address. But may I address that at that juncture? I'm obliged. So, if I may, just dealing with the point that Mr. Young's submission is that he seeks to categorise it as an SOSR case rather than a conduct case. And so his submission is that in those circumstances, FESIT doesn't provide useful guidance. I say in response to that three things. Firstly, if I might...
Well, hang on, we haven't yet quite finished, have we? We found what the Tribunal found at 24.
Yes. All right, well,
What did the Court of Appeal?
Okay, I'll deal with Mr. Young's point then at the conclusion of what the Court of Appeal determined. So, at paragraph 24, which I've just read, it was accepted that the protected disclosure was the context rather than the reason. My summary, but I hope a fair one. Then at paragraph 25, the Tribunal did not spell out why management thought that the only feasible way of resolving the problem was to remove these two whistleblowers rather than those who had subjected them to acts of harassment. However, it was plainly justified that it was management's genuine view that this was the case.
Plainly satisfied.
Yes, indeed. So, we then see paragraph 40 at page 162, where Lord Justice Elias accepted the submission of counsel for the respondent in that matter in these terms. In my judgment, Mr. Linden's first submission is correct. The Tribunal decision shows that it was satisfied that the reasons given...
Sorry, I just want to look at 39, which is what he was accepting.
Indeed. Sorry.
So which is his first submission?
His first submission is
37, is it?
Yes. It's paragraph 37. Mr. Linden makes 2 points with respect to this ground. The first is that the reasoning of the Employment Tribunal demonstrates that even if the appeal tribunal was correct in concluding that the employer could discharge the burden of proof only by showing that the making of the protected disclosure played no part whatsoever in the relevant acts or omissions, that onus was plainly discharged.
Okay, so that's what they're accepting at 40.
Indeed. In my judgment, Mr. Linden's first submission is correct. The Tribunal's decision shows that it was satisfied that the reasons given by the employer for acting as it did were genuine and demonstrated that the fact that the claimants had made protected disclosures did not influence those decisions. The Tribunal noted in terms at the end of paragraph 39 of its decision that there must be a causal connection between the protected act and the respondent's acts or omissions to act. Its reasoning thereafter demonstrates, in my view, that it did not think there was any such causal connection. The Tribunal explained that it was satisfied that, although the employer was open to criticism for not protecting the claimants more effectively than it did, its failure to act more robustly was not a deliberate omission and was not because the protected disclosures had been made.
Well, surely we're more concerned with 41.
Yes?
Which is the positive acts, which is the moving of them. Isn't that right?
Yes.
Let me just... do we need to read the whole 40? Let's just read the whole 41.
If I may, I was going to take you to E.
Okay.
And just by E, you'll see a sentence beginning once...
I need to read the whole paragraph to myself.
Certainly, my lord.
Yes, I've now read the whole of paragraph 41. So what's the particular passages you...
The particular passage is from E. Just below E, you'll see a line one line down, halfway across the line, once an employer satisfies.
It's almost more important, isn't it, the sentence before, where the test seems to be one of genuineness.
My lord, yes. In fairness, the point is made later in that same passage. We have no reason to doubt the explanation that's given, and therefore we should accept it.
Yeah, well, that's a point,
Yes.
and that's a point about the burden of proof. But yeah.
Indeed. So the test is, as I submit, FESIT correctly decides, genuineness. And the final 3 lines of paragraph 41, here the Tribunal was satisfied that in redeploying Mrs. FESIT and Mrs. Woodcock, the employer had acted in order to resolve the dysfunctional situation. I see no basis for going behind that finding, which is essentially one of fact for the Employment Tribunal. Which echoes, obviously, a point I've made several times. This, in my submission, is all a question of fact. it's also important, in my respectful submission, to look at arguments that were then advanced in addition by both the claimants and public concern at work, as it then was, as to why the conclusion of the tribunal ought not to be accepted. This is a rather lengthy passage. It starts at paragraph 46 on page 163 and concludes at paragraph 55 on page 165. It was set out in my skeleton argument in some detail. I'm obviously in the court's hands. I'm happy to read that out if it would assist.
Certainly don't read it out. What I will do, my ladies will say if they want to do something more elaborate than this, I will just, as you say, it's already in your skeleton, I will just skim read that.
I'm obliged.
Then you will take us to the particular points that you have, that you want to refer to.
I'm very much obliged.
Yes.
So, my Lord, taking the invitation to highlight the points which in my submission are important, it can be seen that at paragraph 49, Ms Romney QC, counsel for the then claimant, accepted the application of the separability principle as discussed in Martin and Bolton, but made the point that as it is not suggested the claimants did anything untoward or improper, at all times they made proper disclosure in the public interest, and yet they were not protected by their employer in the way they ought to have been. It would be unjust and contrary to the purposes of the Act to deny them the protection of the law. And the response of the court, paragraph 51, I disagree. I entirely accept that where the whistleblower is subject to a detriment without being at fault in any way, and I pause and observe, not this case, for the reasons that we'll look at in due course, but I entirely accept that where the whistleblower is subject to a detriment without being at fault in any way, tribunals will need to look with a critical, indeed sceptical eye to see whether the innocent explanation given by the employer for the adverse treatment is indeed the genuine explanation. The detrimental treatment of an innocent whistleblower necessarily provides a strong prima facie case that the action has been taken because of the protected disclosure and cries out for an explanation from the employer. Then at paragraph 52, an important point which foreshadowed an observation made by my Lady Justice Laing, that what one can't have is a situation that through an exercise of legal deduction, the employer's reason is treated as something that it is in fact not. So what the court said at paragraph 52 is this: the consequence of Ms Romney's submission, however, is that there could be no explanation which the employer could offer in these circumstances which would relieve him from liability. The need to resolve a difficult and dysfunctional situation could never provide a lawful explanation for imposing detrimental treatment on an innocent whistleblower. I do not think that can possibly be right. It cannot be the case that the employer is necessarily obliged to ensure that the whistleblowers are not adversely treated in such a situation. This would mean that the reason why the employer acted as he did must be deemed to be the protected disclosure, even where the tribunal is wholly satisfied on the facts that it is not. And then a number of policy arguments are put forward. Paragraph 53, it might be an impossible objective because you can have competing
There's no need to read all that out. You've just read it, yeah.
Yes, indeed. But summarising, you can have competing whistleblowers. Paragraph 54. It might not be practicable to resolve the situation because the individuals who are said to have subjected to detriment may be key to the business. And then paragraph 55. As both the Employment Tribunal and the EAT accepted, these are extremely difficult conflicts for an employer to resolve. This employer dealt with the situation inadequately, as the Tribunal found, and indeed may well have been in breach of the contractual obligation of trust and confidence owed to these claimants by failing to take more active steps to prevent harassment by colleagues. But the question here was whether the employer had victimised these whistleblowers within the meaning of the statute definition. The Tribunal concluded that it had not, and in doing so was plainly fully alert to the fact that these claimants had been harshly treated by at least some colleagues. I therefore reject Ms. Romney's submission on this point. And that encapsulates our submission, that this is a question of fact. It involves looking at difficult situations and properly extracting the reasons for the employer. And having extracted those reasons, asking the simple question, are those reasons the protected disclosure or are they not? It's also important in the light of the suggestion that this is a rule of law, that separability is in fact a rule of law, to look at submissions which were advanced by public concern at work. Mr. Allen, QC, on behalf of public concern at work, as the court will see at paragraph 56, sought to read words into the Public Interest Disclosure Act at section 47B to allow a protection in circumstances, well, the wording was, done on the ground that it undermines the protection to which he or she is entitled by the legislation and must have if the public interest is to be secured. Now, that construction was rejected by the Court of Appeal in paragraph 61, but they made an observation which in my submission is important, and again foreshadows an observation made by my Lady Justice Laing, as regards the fact that if Parliament had wanted the protection to be as wide as Mullern and Friends contend, it was open to them to legislate. So at paragraph 61, in my judgment, there's nothing surprising in Parliament considering that the principal protection which needs to be afforded to whistleblowers is from retribution by the employer. It may be that particular interest groups with an interest in this legislation could agree protection to that extent but no further. This is of course mere speculation, but in my view it shows why it would be inappropriate to assume that Parliament intended a fuller protection than naturally arises on the words of the statute. I therefore reject the submission that the Employment Tribunal erred in failing to give this construction to section 47B. I recognise why the claimants feel aggrieved. I accept too that Mr. Allen may be right to say that if the Tribunal decision is allowed to stand, it means that on one view of the matter, whistleblowers are inadequately protected. If so, for reasons I've given, any remedy must lie with Parliament. The reason I emphasise that is, of course, the whistleblowing provisions were amended following Fessett to allow vicarious liability for the acts of co-workers. No attempt by Parliament to legislate to add the rule of law or the presumptive requirement which Mullern and Friends advocate. And I say that that's significant. One wrap-up point, as it were, as regards Fessett. I also observe that plainly the dysfunctional situation which the employer sought to resolve arose from the conduct of the individuals by raising protected disclosures. Nowhere in Fessett is there any suggestion that the criterion of separability ought to be wholly unreasonable or serious misconduct. Indeed, positively, it was found by the Court of Appeal that the whistleblowers in Fessett had behaved properly. I come now to the points I was going to make slightly earlier about why Mr. Young's attempt to suggest that facet is not appropriate or is not helpful guidance in this context, and why I say respectfully they're wrong. The first observation I would make is that my learned friend, Mr. Young, seeks to categorise facet as a some other substantial reason as opposed to a conduct case. If I could borrow the observations of my Lord Justice Underhill in a number of cases about the fascination of the employment bar with some of the substantial reason as contrasted with conduct. The reality is what was said to create the situation was the conduct of the individuals. And so I say any distinction is in principle incorrect. And secondly, bearing in mind that separability is advocated by my learned friends to be an objective principle, which ought to apply irrespective of the nature of the claim, it is difficult, in my respectful submission, to understand why there's then a principled suggestion that, okay, in an SOSR case, as it were, separability is easier to satisfy than it is in a conduct case. In my submission, there's no principal basis for that distinction, and it's not supported by the authorities. So those are my submissions as regards facet. I don't propose to go through any of the other whistleblowing decisions, save to say the court's been taken to the reasoning in Panayotou. And all I say in Panayotou is that the reasoning of Panayotou is that the reasoning in Panayotou accords entirely with the reasoning in Martins, Page, Bolton School, and also facet. There's no suggestion of a criterion of exceptionality. There's no suggestion that the behaviour has to be serious misconduct or seriously unreasonable. There is simply a recognition that it is a question of fact for the tribunal that needs to look at matters closely and carefully, and having looked at matters closely and carefully, for it to determine what the true reason is. My Lord, then dealing with the extent to which there's helpful guidance to be taken from the trades union cases and the health and safety cases, I essentially repeat points that I've made before. Namely, all of the authorities are essentially looking at a similar sort of thing, and what they're trying to do is identify circumstances where properly a distinction can be drawn between what has been done and the manner of its performance. And all of the authorities, as I say, as I've said several times, are simply examples of the application of that principle rather than defining its scope. And simply to make out that submission, could I take the court to the judgment in Morris, which is tab 19, please, of the authorities bundle, and if I may, could I pick matters up at page 312? This is taken from my Lord Justice Underhill's judgment in Morris, and at paragraph 19, my Lord and the court discussed the extent to which, in the trades union context, there was helpful guidance taken from Mihaj or Bass. And if I may pick matters up at the line below D, which begins, things in question can fairly be regarded. Does everyone have that?
Mm-hmm. Yep.
Thank you. Things in question can fairly be regarded as a distinct reason for the dismissal, notwithstanding the context in which they occurred, and his reference to acts which are wholly unreasonable, extraneous or malicious seems to me to capture the flavour of the distinction. That precise phraseology should not be treated as definitive, but the point which it encapsulates is that in such a case it can be fairly said that it is not the trade union activities themselves which are the brackets, principal close brackets reason for the dismissal, but some feature of them which is genuinely separable. As Amanoff Qual is a good illustration of such a case, the employee's deliberate breach of confidence could fairly and sensibly be treated as a reason for dismissal distinct from the fact that it occurred in the context of trade union activities. And I say those words, fairly and sensibly, are the best. If one were to look for a means of encapsulating the separability principle as succinctly as possible, it's fairly and sensibly. Can a distinction fairly and sensibly be drawn? And armed with that analysis, which we respectfully submit is the proper approach to the separability principle, my lord and my ladies, one turns to the factual analysis of the judgment. Now, my approach is going to be slightly different from that of my learned friends, in the sense that my learned friends lifted passages entirely properly, but didn't look at the judgment as a whole to the same extent which I'll invite the court to do. Because in my respectful submission, it's important to recognise a number of factual findings which underpin the essential conclusion. But without wishing to, well, I'll make the obvious point. The obvious point is, our submission is that the tribunal's judgment was plainly correct and adequately reasoned, and that His Honour Judge Auerbach's analysis of that judgment and why its conclusions were appropriate and indeed ones which could not be disturbed is an analysis of as regards which I respectfully cannot improve and which I urge upon the court. But I do propose to go through some of the factual findings to hope to make out that analysis. In that light, the starting point in my respectful submission is to recognise the protected disclosures that were material to the tribunal's decision. Now, my learned friend Mr. Young has taken you to page 261, which is paragraphs 53E and F. And I would just wish to highlight two additional points arising from my learned friend's entirely proper indication of the factual findings in this regard. The first is that PD3 was made on the 26th of September 2018. And PD3 encompassed the MRPA concern, the bank-to-bank lending issue. And we see that PD4 was made on the 22nd of October 2018 and was a reiteration of PD3. Turning over the page, PD9 is the 2017 GIB AIM Fund Management Audit Report, the final GTOP report, issued on the 26th of November 2018, which included the same matters as PD3 and PD4. And that's, in my submission, important because we look at some of the things that Mr. Mohammed did in terms of his view of the PDs in due course. Now, there is obviously, in the background, there is a history of concerns being expressed by a number of the claimant's co-workers as regards the manner of her work. Now, it's right to say that the tribunal was critical of a number of those concerns and didn't, for example, as regards Rod Sutton, didn't feel that they were supported by evidence. But conspicuously, what the tribunal did not find was that those were that those were not genuine views held by the claimant's co-workers. And just one brief example to seek to evidence that point. Page 265, paragraph 72. As regards David Maskell, Mr. Maskell had been told by the former head of Treasury, Mohammed Sabitri, I think, who left the respondent in 2017, that he had concerns that the claimant did not sufficiently understand the products and the business. Mr. Sabitri told Mr. Maskell he had spoken to Mr. Al-Mullah about this, but Mr. Maskell does not know whether Mr. Al-Mullah passed this feedback on to the claimant. Mr. Maskell, for his part, had limited direct contact with the claimant, although he had been audited by her occasionally. He said that he found her approach to be challenging, as she had a pernickety approach and could be inflexible. He contrasted that approach with that of the Bahrain audits. And then if we go to paragraph 74, my lord and my ladies, you'll see we accept that insofar as Mr. Maskell had concerns about the claimant's approach, those were genuine concerns. And if necessary, I can identify other examples of this, but in my submission, it's a fair summary of the tribunal's judgment to say a number of the claimant's colleagues expressed concerns. We personally didn't agree with them, but we don't say that they didn't exist. As regards Alison Yates, who was the head of HR and on the tribunal's finding played an investigative role, we see a number of findings as regards her and her view of the claimant, which in my submission are important to consider. So, starting at paragraph 94 on page 269, she herself had concerns, paragraph 13, about the way in which the claimant handled the process of dismissing her direct report in the summer of 2015. She considered the claimant was sharing too much information related to GIB UK's process, and she expressed this concern both to the claimant and to other colleagues. Moving on to paragraph 105, which is on page 272. The context of this is there is a discussion of the second audit report in 2017 when a suggestion had been made in the audit report that the claimant had behaved deceitfully. And the reference to that is at paragraph 103. The tribunal picked matters up at paragraph 105 and said this: the word deceitful is strong language to use without any supporting evidence. Mr. Mohammed appears to have discounted the allegation altogether as being an evidence. Ms. Yates, when questioned, effectively said that she had not done anything about it, as she agreed with it. Then, paragraph 110 on page 273. There was some involvement, so the heading is the AML audit. There was some involvement from HR after this, as emails in the bundle, page 242, reflect the view of HR that the relationship between the claimant and Mr. Sutton in particular was deteriorating. The emails show that HR regarded the problem as being with the claimant and identifying a need to speak with Mr. Mohammed about it. And then the final finding as regards Ms. Yates is paragraph 120 on page 275, please. And this deals with the Jose incident where a then former employee, Mr. Kanaka, was leaving the building having cleared his desk, and the claimant went to speak to him. The finding is at paragraph 120. Ms. Yates' attention was drawn to this conversation by another colleague, and she immediately went over to put a stop to the conversation, which she considered to be wholly inappropriate for obvious reasons. It's also appropriate, seeing we're at paragraph 120, just to deal with some findings as regards Mr. Mohammed. Later on in that paragraph, my Lord, counting 1, 2, 3, 4, 5. My Lord, my ladies, forgive me. 8 lines down, my Lord and my ladies, do you see the line beginning, would have done the same again?
Yes.
Okay. Would have done the same again if the circumstances arose. Ms. Yates considered it to be remarkable that the claimant did not recognise her error of judgment in this regard. Mr. Mohammed, when told about this incident, also considered it to be completely inappropriate conduct, and he told the claimant so at the time. Additional findings as regards Mr. Mohammed.
Why are we being shown all this? Speaking for myself, I haven't quite understood why it was so inappropriate, but we're a long way from many of the issues in this case, aren't we?
Well, I'm seeking to set the background because the finding of His Honour Judge Auerbach in the EAT, which I seek to urge upon the court as a proper construction of the judgment, is that a theme which runs through the judgment is that the claimant's interactions with her colleagues were problematic, and that the reason for the dismissal was that this theme had manifested itself in an incident which was so serious with its effect on an individual that she had to go. And so I'm seeking to, in fairness, I'm just about to finish on that point, but I was seeking to evidence the basis for that. Okay. So, my Lord, there are 2 further points about Mr. Mohammed. May I briefly...
Actually, just while we're on it, paragraph 123, the ET explain why they think it was inappropriate.
Indeed.
Yes, I see. Yes, I should have remembered that. Yep, thank you.
I'm obliged. So the 2 other findings as I sought to address as regards Mr. Mohammed is page 270, paragraph 95. Mr. Mohammed, as the claimant's line manager, consistently rated her highly, although he agreed that there are times he had to step in to redraft her report so as to express matters more concisely. In general terms, he was always very supportive of the claimant, but ultimately, he frankly admitted in oral evidence, he agreed to dismiss the claimant in the light of her email to Miss Harding on the 23rd of October 2018. We deal with this below. And of course, the point made in my skeleton, and I make again, is that wasn't a protected disclosure. And it was the behaviour on the 23rd of October in the email, which in Mr. Mohammed's mind was the reason for dismissal. So, moving on to the Tribunal's findings about protected disclosure 4, in our submission, the Tribunal was repeatedly careful, for reasons which I'll seek to demonstrate very briefly, to draw a distinction between the protected disclosure and the legal awareness issue. And in my submission, there are a number of passages where that distinction can plainly be seen. Can I pick matters up at paragraph 141, please, on page 279? Ms. Harding's evidence was that the claimant immediately raised the issue in the email.
Sorry, which paragraph?
141, my Lord.
Yep.
Ms. Harding's evidence was that the claimant immediately raised the issue in the email about why Ms. Harding did not realise that the MRPA was a bank-to-bank document. It was clear from the claimant's evidence to the Tribunal it was still a very important point for her. It is her PD4, and that she considered that this was a point that Ms. Harding ought to have known. We therefore accept that the claimant raised this with Ms. Harding and questioned her awareness about the matter that constituted her PD4. So the first...
So just to understand that,
yes,
it was implicit in PD4 that she was challenging Miss Harding's legal awareness, because Miss Harding, as I understand it, was responsible for the template.
Miss Harding was responsible for the template. So, as the tribunal later says, and we'll look at the finding in that regard, it's not a necessary part of PD4 to question Miss Harding's legal awareness, because the problem was that the document, in her view, didn't adequately protect as regards bank-to-bank lending. And that's a distinction which the tribunal itself recognised. And my submission is...
So where is that? Where do they recognise that?
They recognise that... Forgive me. Excuse me for a moment. It's page 298,
Yeah.
paragraph 215E.
Sorry, what was that again?
Page 298, paragraph 215E. And it's the final 4 lines.
The first sentence is that the professional awareness point was inseparable from PD4.
Forgive me, was inseparable in this case from the protected disclosure itself. And I seek to explain why I say the tribunal make...
The next sentence says that the making of PD4 in and of itself entailed implicit questioning of Miss Harding's legal awareness, because she had overseen the putting in place of the MRPA.
As regards Miss Harding, yes, and that's not a finding from which I seek to dissent. But it goes on to say, we acknowledge that it is not a necessary part of a protected disclosure in law to add to PD4 words such as, it's a matter of legal awareness. But we find that in this case, the claimant did not raise her concerns about Miss Harding's legal awareness in an unreasonable way. So, my overarching submission is that when one looks at paragraph 215, well, let me deal with it now. If one begins at page 297, paragraph 215, what the Employment Tribunal is doing here is looking in the mind of Jenny Harding to ascertain whether Jenny Harding was materially influenced by the protected disclosure. And the fact that the tribunal, in my submission, is limiting its analysis to her and her thought processes can be seen from the first sentence of paragraph 215. We find that Miss Harding's treatment of the claimant on the 22nd and the 23rd of October was materially influenced by the protected disclosures that the claimant had made. We reach that conclusion for the following reasons, and then we see at 215A, Miss Harding's treatment of the claimant on the 22nd and 23rd of October 2018 comprised the following key elements. So,
I understand that, Mr. Siddle, but the point that you appeared to be making a moment ago, you're now making the point that this is all about what was in the mind of Jenny Harding.
my lady, yes?
Earlier, the point you made was that it was not a necessary part of PD4, that it questioned Jenny Harding's legal awareness.
Yes, indeed.
And I asked you to show me the passage where the tribunal recognised that. But I don't read 215E as recognising that. To the contrary, it seems to me that there the tribunal was saying it was implicit in PD4 that it was questioning Jenny Harding's legal awareness.
Well, my lady, this is the source of that submission, and I can't better on the point that I've already made.
I wonder whether there's just you're not really. It's not clear you're really arguing about anything substantial. I read the argument, the point being made as, or the distinction being made in 215E, is that it is necessary in making PD4 implicitly to question Ms. Harding's legal awareness, because you are saying that the template doesn't reflect a fact of which she in her role ought to have been aware. They go on to acknowledge that you didn't have to spell that out. I mean, to put it crudely, you can say this is not this document doesn't do what it should.
Yes.
Without saying, and someone in your role should
No better.
know better.
Lord, yes.
Or I can't see why you didn't understand that, you ignorant so-and-so. Now, he didn't go that far, but then I'm just putting in rather more extreme terms to say you can make the substantive point, which necessarily involves some criticism, without making the criticism explicit.
Yes.
Now, where that distinction goes is another matter, but that, it seems to me, is what they're saying in EE, isn't it?
And so, my lord, I respectfully agree.
I mean, a perfect person probably wouldn't have made it explicit. A sensitive person wouldn't have made it explicit. All that matters is they make the substantive point.
My lord, yes.
And this is all explaining why Miss Harding was so touchy about it, because she recognised that the professional awareness point was part of the PD4, and so she recognised that PD4 was a criticism of her personally.
Yes,
Yeah,
and
but it goes word because clearly things were said at the meeting which didn't, as she exaggeratedly understood it, impugn her professional integrity, but did impugn expressly
Yes.
her professional competence. And that was said again in the email.
my lord, yes,
In
and so,
quite measured terms, but nevertheless said expressly when it needed to be.
my lord, and so coming back to the beginning of this, the question from my lady Justice Simler, I say, and may I thank the bench for expressing it far more lucidly than was I. There's a recognition within the judgment that it isn't a necessary element of PD4 to raise the question of professional awareness. Now, as regards,
Well, all right.
as regards,
It's more that you needn't raise it expressly.
yes.
Yeah.
So that's the base of my submission.
Yeah, okay. Well, I think, speaking for myself, but perhaps unsurprisingly, as I put it to you, I understand that distinction.
Yes.
Quite where it goes,
Remains to be
in
seen.
terms of the legal submissions, remains to be seen.
My lord, yes. And I also, so what I was dealing with was where I submitted that the tribunal's findings demonstrated that they had in their mind a distinction between PD4 and legal awareness. Now, I'd taken you to paragraph 141, which I said was an example of that. A further example in my submission is page 280, paragraph 144. Now, in paragraph 144, the tribunal's resolving the dispute between Jenny Harding and the claimant about whether professional integrity was raised, and they conclude that the claimant's account is to be preferred. But looking at the last 3 lines of paragraph 144, we see what upset Miss Harding and led to Miss Harding walking out, slamming the door, however, was what the claimant had said about PD4 and her legal awareness of that issue. And without wishing to labour the point, a final example of the tribunal recognising that distinction, page 297, paragraph 215A2. Ms. Harding became more agitated when the claimant made her PD4 and questioned her lack of awareness of PD4. So what I say is that the tribunal, throughout its findings, was recognising that there was a distinction between the fact of PD4 and the professional awareness issue.
Well, again, you're not putting it, it seems to me, in the clearest way. What you
forgive
mean
me.
is they recognised there was a distinction between the necessary criticism implicit in raising the PD4 issue at all,
My lord, yes.
and spelling out to Ms. Harding that it bore on her professional competence.
My lord, yes.
That
Two other findings which in my submission are important in assessing the tribunal's approach to its eventual finding. In fairness to Mr. Young, you were taken to both of them. Page 304, paragraph 235b, the final two lines of that paragraph, where it was said that the claimant didn't raise issues sensitively.
Where are we, sorry?
304, paragraph 235b.
Yep.
And then, in the context of the constructive dismissal complaint, forgive me, not constructive dismissal, contributory fault argument, page 307, paragraph 242c. Our findings on this are set out at paragraphs 128, 164, 215 and 228 above. We have found that in that incident, Ms. Harding unlawfully subjected the claimant to a detriment for having made protected disclosures. Moreover, although we recognise the claimant on that occasion expressed herself robustly and inappropriately to Ms. Harding, both orally and in her subsequent email.
What about the submission that is difficult to reconcile the finding of inappropriateness with 215E? Mr. Young's submission.
I have to accept that there is arguably a tension as to whether one can be robust and inappropriate, but yet remain unreasonable. Sorry, but remain reasonable. What, in my submission, the tribunal is looking at here is effectively the Martin's point. So, whether, when assessing Jenny Harding's response, and whether Jenny Harding is materially influenced by the protected disclosure, is the raising of legal awareness unreasonable in the sense that would engage the Martin doctrine as regards Jenny Harding and allow separability? So I say, on the face of it, there's an arguable tension, but properly considered, bearing in mind what the tribunal's addressing in paragraph 215E, it's addressing the Martin's point, so the tension doesn't in fact exist in my submission.
Okay.
So we then need to look at the email of the 23rd of October, just briefly, which is page 281, paragraph 155. Now, it is right to say that the tribunal described the claimant as seeking to be conciliatory in tone and careful, but accepted, going over the page, that it specifically raised the question of legal and professional awareness twice. And
Where,
you see it
where does it say that?
They're both in the second paragraph on page 282.
I see, sorry.
But then the tribunal goes on to say, at paragraph 156, for the avoidance of doubt, we again find that in this email the claimant was, as she made explicitly clear, questioning Ms. Harding's legal awareness and not her professional integrity. But the wording of the email demonstrates that the term is used twice. Now, there are three additional findings to which, in my submission, the court needs to be taken in judging the wording of the email of the 23rd of October. Now, I make the point, obviously, the 23rd of October email is not asserted to be a protected disclosure. Paragraph 160 on page 283 is Mr. Mohammed's reaction to the email. Following receipt of the blind copy of the above email from the claimant, Mr. Mohammed telephoned the claimant and spoke to her for over an hour. He told her that the email was totally unacceptable. As he explained in his witness statement to the claimant, contrary to everything he thought he had told the claimant previously about not allowing interactions to become personal, it called Miss Harding's competence into question, suggesting twice that she lacked legal or professional awareness. He told the claimant that he could not defend this behaviour. He urged her to apologise to Miss Harding. So, what is not a protected disclosure, and as has been demonstrated repeatedly by looking later in the judgment, the tribunal found that Mr. Mohammed had no issue with the subject matter of the disclosure, and his immediate response is that he could not defend the behaviour as seen in the email of the 23rd of October. The suggestion by my learned friend Mr. Young, well, it's nothing more than a repetition of PD4, in my respectful submission, misses the point. The point being, it's not what was PD4 which caused Mr. Mohammed the concern. It was the concern that he had called Miss Harding's competence into question, suggesting twice that she lacked legal or professional awareness. Two other findings. Paragraph 164 on page 284. Following a meeting between the claimant and Jenny Hardy, the claimant for her part considered that matters were resolved and proceeded to finalise the GTOP audit report. She messaged Mr. Mohammed to this effect, which she understood as indicating that the claimant had apologised and instructed. In fact, the claimant had not done so, and Miss Yates and Miss Garrett-Cox, we find, inclining to the view that the claimant should be dismissed.
I'm so sorry, it's my fault entirely. Could you just repeat that paragraph reference?
Certainly, it's page 284, paragraph 165, my lady.
Thank you very much.
Not at all. Also, page 283, paragraph 162, Miss Harding and the claimant met again on the 24th of October 2018. Miss Harding's evidence, which we accept, was that the meeting was productive and that the claimant to some extent recognised that she had made a mistake.
Read on.
Forgive me?
When reading on the next sentence.
Not at all. But Miss Harding also said that so far as our professional relationship was concerned, the damage had been done. So we then move to the findings as regards dismissal, which have been which have already been identified. So I propose to take these very briefly and simply say a conspicuously one-sided briefing is prepared by Ms. Yates to Ms. Garrett-Cox, but that one-sided briefing was not at any stage found to have been not genuine. And there's a specific finding in the reconsideration judgment that in preparing this, Ms. Yates wasn't in any way motivated by a protected disclosure. There's a meeting with Mr. Mohammed, and it's important that we read page 286, paragraph 169, where the basis of Mr. Mohammed's agreement to dismissal is set out. If I could start matters at the line beginning otherwise, which is approximately 7 lines down. Does the court have that?
Yeah.
This is because we consider it would have been plain to him from the fact that Miss Garrett-Cox and Miss Yates had travelled to Bahrain especially, and from their approach as reflected in Ms. Yates' briefing email in advance of the meeting, that dismissal was the outcome they sought. We find that the dominant factor in his agreement to dismissal was that he considered the email to Miss Harding on which he had been blind copied to be unjustifiable and career limiting. He also considered her actions regarding the previous incident with Jose Canaco to have been deeply inappropriate. See above paragraphs 118 to 123. And my lady Lady Justice Laing took the court to 123, where the explanation of the reason for the inappropriateness is set out. Paragraph 171, casting our mind back to the start of this evidential review, is PD 9, and it was noted that on the 26th of October 2018, the final fund management audit report was issued. It was signed off by both the claimant and Mr. Mohammed and rated the internal control processes falling within the scope of the audit as generally unsatisfactory. This was the first time that the UK business had received such an audit rating, although the claimant had given one in Bahrain. So, findings then as to the motivation for dismissal, page 288, paragraph 180. This is the dismissal letter, or sorry, the dismissal letter is at paragraph 178, and the tribunal is reviewing it, and at paragraph 180, it's recorded that Miss Garrett Cox, it's the last three lines of the paragraph which in my submission capture the point. Paragraph above, a sentence above. Inevitably, given her position and minimal personal interaction with the claimant.
Sorry, I've got lost now.
Okay, forgive me.
Which paragraph are we in?
We're in 180.
Where do I find a sentence starting inevitably?
4 lines from the bottom, you'll see a line.
You started in the middle of a bracket.
Yes. So anyway, we find that Miss Garrett Cox's view was inevitably.
Okay, sorry.
Forgive me. We find that Miss Garrett Cox's view was inevitably, given her position and minimal personal interaction with the claimant, again an expression of her opinion that the claimant's conduct towards others warranted dismissal, not that Miss Garrett Cox personally no longer wished to work with the claimant. So Miss Garrett Cox's view was her conduct towards others warranted dismissal. In my submission, the tribunal's directions of law in this matter can't, and indeed are not criticised. In my submission, they were entirely correct. And so we come to paragraph 215. Now, essentially, I've made my submissions about what the tribunal is deciding in paragraph 215. In paragraph 215, what the tribunal's doing is looking at the mind of Jenny Harding and deciding why she decided to act as she did, or what motivated her to act as she did. And for the reasons I advanced in response to the question from my Lady Justice Simler, I say what the tribunal is doing is entirely properly focusing here on Jenny Harding's mind. And as I've said, as a result of the passages that we've already looked at as to the distinction which the tribunal drew between the making of the disclosure and the direct questioning of legal awareness, I say that's a distinction that the tribunal had in mind when it comes to its findings as regards dismissal. And it's to those findings as regards dismissal I now turn. My Lord and my Ladies, if we go to paragraph 221, please. We have a finding that the cause of the claimant's dismissal was the incident with Miss Harding on the 22nd and 23rd of October. We so find because despite the various concerns expressed by the respondent's witnesses about the claimant over preceding months and years, there's nothing to suggest that dismissal had been contemplated prior to this incident. So, as it were, the first stage of the separability argument engaged with, the fact that the protected disclosure or conduct which immediately follows on from the protected disclosure is the cause of the incident. So the tribunal then moves in my submission entirely properly to then consider whether cause ought to be treated as being the same as reason. And in my submission, it entirely properly approaches this exercise, because what it says is, in some cases, our finding in the previous paragraph as to the principal cause for dismissal would be a sufficient finding also as to the reason for dismissal. In this case, however, Since the respondent relies on alternative potentially fair reasons for dismissal, conduct or SOSR, and since the claimant contends that the principal reason for dismissal was her protected disclosures, and because we have found that the incident with Miss Harding on the 22nd and 23rd of October involved Miss Harding subjecting the claimant to detriment for having made protected disclosures, we've considered very carefully what it was about that incident with Miss Harding that constituted the principal reason for dismissal. So it recognises the need to scrutinise arguments of this nature with care. It goes on to say, we have to decide what part or aspect of the Harding incident it was that constituted the principal reason for dismissal, and whether that reason is to be categorised in law as being conduct, some other substantial reason, or the claimant's protected disclosures. So, recognising that the Harding incident isn't looked at, as it were, as an amorphous whole, there's a need to recognise what part or aspect of the Harding incident is the reason for dismissal. It's then important to recognise that at paragraphs 223 and 224, what the Tribunal is engaging with is the jutty exercise of attribution. And that's plain from the bottom of paragraph 222, and is seeking to identify who, for the purposes of the statutory test as identified in Bayet and other cases, who are the relevant decision makers. And the Tribunal's conclusion is that it's Mr. Mohammed and Miss Garrett Cox who are the decision makers, but Ms. Yates' involvement is such that, as an investigator, is such that there can be regard had to her view of matters. It then, at paragraph 224, while still dealing with the jutty question, addresses the position of Miss Harding. And it comes to the conclusion that Miss Harding's motivation can't be attributed to the employer. And I say that that's important. And the reason I say that that's important is because it demonstrates the Tribunal having a valid, and indeed not only a valid reason, but a requirement to put to one side its findings about detriment, because it's no longer looking into the mind of Jenny Harding, it's now looking into the minds of Mr. Mohammed, Miss Garrett Cox and Miss Yates. We pick matters up now at paragraph 225. We have next considered what precisely it was about the incident with Miss Harding that led Miss Yates, Miss Garrett Cox and Mr. Mohammed to decide to dismiss the claimant. And at this point there's a distinction, or there's a division between Mr. Mohammed on the one hand and Miss Garrett Cox and Miss Yates on the other. So Miss Yates and Miss Garrett Cox form the view that the claimant had questioned Miss Harding's professional integrity. Now, that decision, or that view, was wrong, as the Tribunal has found as a matter of objective fact. But what the Tribunal didn't do, or didn't find, is that that wasn't a view held by Miss Garrett Cox or Ms. Yates. Now, as regards Mr. Mohammed had appreciated the distinction between questioning professional integrity and legal awareness. And, my lord, that's roughly halfway down paragraph 225. I think the passage may be familiar, but I can obviously identify it if it would assist. So then the Tribunal goes on to say, while we consider that there is an important distinction between questioning professional awareness and questioning integrity, we do not consider it would have made any difference to Miss Yates or Miss Garrett Cox's approach if Miss Harding had used the right terminology. So what the Tribunal's doing here is dealing with the jutty point about invention, because they go on to say, accordingly, although there was an element of invention in Miss Harding's use of the word integrity, we do not consider that it is an invention of the sort that the Supreme Court had in mind in jutty. To attribute to the dismissal decision makers here Miss Harding's motivation on the strength of the dismissal decision makers' forgive me, on the strength of an issue as to terminology such as this is not, in our judgment, the correct legal approach applying the principles in Jutty. So what the tribunal has found is that there is a division in the decision makers. Two of them consider that the claimant challenged the professional integrity of Jenny Harding, which plainly would be a serious matter indeed, and in my respectful submission is a proper basis of distinction, even if one were applying the full stricture of the Martin's line as advocated by my learned friends. As regards Mr. Mohammed, he recognises that it's not a challenge to integrity, it's a challenge to awareness, but he thinks, notwithstanding that, dismissal is appropriate because he considers wholly inappropriate, and also he considers the Jose Canapa incident to be wholly inappropriate. Now, having constructed or having identified the precise factual nexus, we then look at the tribunal's finding at page 301, paragraph 226. We accordingly find that the respondent's principal reason for dismissal in this case was that the claim to question Ms. Harding's professional awareness integrity. So the tribunal recognises and applies the distinction between the various decision makers, both orally in the meeting on the 22nd of October 2018 and in the subsequent email of the 23rd of October. That, in our judgment, was a matter of conduct on the part of the claimant, and we accordingly find that the principal reason for the claimant's dismissal was her conduct. Now, in my respectful submission, having analysed the judgment in the manner that I have, which respectfully I urge upon the court, I submit that that is an entire... If matters had stopped there, that would be an entirely permissible and correct finding. But matters don't stop there, in my respectful submission, because what we see at paragraph 228 is a discussion of the impact that the disclosure had had on Jenny Harding. Now, simple hurt feelings in and of themselves, as I conceded in my skeleton argument, we wouldn't seek to argue that that is a proper grounds of separability. But what we say is that properly analysing the judgment, what the tribunal is recognising is the significant impact of the wrongdoing which had already been identified on the part of the claimant on a co-worker. And that's a factor emphasising why in this particular case it was felt dismissal was appropriate, whereas in other cases it might not have been.
Yes, but the reason why they're even considering that question is that they think, although I'm not sure I've quite got to the bottom of their reasoning, that it goes to the duty question.
Yes. The other observation I would make is it might arguably go to fairness questions in due course. Because
well, I dare say, but I think we've got to look at what their actual reasoning was.
Certainly.
As you say, they've given their conclusion, which is already to some extent reasoned.
Yes.
At 223 to 225 produces a conclusion at 226. Then they deal with three further points for completeness.
Yes.
Which obviously not inconsistent with their previous reasoning, but draw out points which don't appear from it. Since their previous reasoning was also looking at duty, 228 appears to be directed to that.
Indeed. If I may say so, it's expressly so, as your Lordship no doubt would have appreciated, because it's a discussion of whether the nature of the invention is such that it triggers the Jutty principle.
Yes, I mean.
So there's a bit of an invention on their findings of fact.
Yes.
Because the claimant did not impugn Ms. Harding's integrity, but nonetheless, even taking that into account, there is genuine upset.
Yes, and if I may, my lady, I think what the tribunal's getting, or what I submit the tribunal's getting at here is the employers had regard to the effect of the incident upon Jenny Harding in coming to its conclusion as to what to do. The reason for dismissal is the reason which is in the mind of the relevant decision makers, of which Jenny Harding is not one. However, if someone in the hierarchy of responsibility, which the tribunal in this case found Jenny Harding was, engages in an invention, the Jutty principle says it can be treated as the reason or part of the reason. So what the tribunal, in my submission, is doing is looking at another factor which has operated on the mind of the respondent in the context of the seriousness of the incident, and is asking itself, is this an invention? Because we found that objectively it wasn't true. Forgive me. We found that she's exaggerated it, but is this a sufficient invention that therefore can be fed into our assessment of the tribunal's reason? Forgive me, the employer's reason. And the tribunal says no, because it's not a sufficient invention to engage the Jutty principle. So a very long answer to a short question. They're dealing with Jutty here. They're not dealing with the essential reason in my response.
I can't resist saying that I'm slightly dismayed at what Lord Wilson said in Jutty, seeming to develop a whole lot of case law that seems to depend on whether or not something constitutes an invention. But that's not for us today. So, having expressed it, I will say no more.
That's a whole other discussion, if I might respectfully say that. Yeah. So then we go to 229, and 229, unsurprisingly, is at the forefront of my submissions, because here the tribunal grasps the fundamental nettle. Having made the finding about reason, it then expresses in terms, secondly, we should, for the avoidance of doubt, make clear that we do not find that Mr. Mohammed, Miss Garrett-Cox or Ms. Yates were motivated by the claimant's protected disclosures when taking the decision to dismiss. None of them looked in any way at what led up to the incident with Miss Harding or at the underlying issues that were of concern to the claimant in her protected disclosures. And I say, if ever there were a clear finding of fact, that is one, and I say that that clear finding of fact demonstrates the entirely permissible distinction which has been sought to be drawn between the fact of the disclosure, and at the risk of trespassing on ground which may encourage some dispute, but the fact of the disclosure, you don't, as part of that disclosure, expressly need to raise professional awareness. But in any event, of the three persons whose minds are relevant for determining the question of the reason for dismissal, two of them thought that that didn't matter anyway, because what had happened was that there was a direct challenge to professional integrity. So, in my respectful submission, when analysed in that way, this judgment is entirely correct, and with great respect, the submissions advanced by my learned friend Mr. Young fall away. And I'll just take them very briefly, if I may. Firstly, I say the finding as regards separability in the context of Jenny Harding in no way dictates the finding of separability as regards unfair dismissal, because you're looking in the minds of different persons who are considering different factors. And so I say that there isn't an internal contradiction between the findings of the tribunal when properly understood, nor do I say, or nor do I accept the suggestion that there's a different test being applied. Quite simply, the tribunal did what it's supposed to do, and did it, in my respectful submission, remarkably conscientiously. And then on the suggestion that the tribunal erred in drawing erred in concluding that separability could be made out. I say respectfully that this is a perversity challenge, and I say, with great respect to my learned friend Mr. Young, his submissions come nowhere near the appropriate threshold for the court to intervene on grounds of perversity. And his alternative submission that there's some sort of halfway house, respectfully, I didn't quite follow. It seems to me that it's either a question of fact, it's a question of law, or it's a mixed question of fact and law, which is a remarkably high threshold for intervention in any event. And so, for all of those reasons, I respectfully submit that this appeal should fail. I then ought briefly to deal with the structured decision-making proposal advanced by my learned friend Mr. Laddie on behalf of Protect. And simply I say, with great respect to him and those who instruct him, it doesn't accurately reflect position in law. Such guidance as is required is already found in the judgments, particularly of Page, and rather than it being a useful decision toolkit, as my learned friend would encourage upon this court, in my respectful submission, it raises the difficulty of causing more problems than it solves. So for all of those reasons, I invite the court to dismiss this appeal. May I just briefly turn my back on the court to ensure I've covered everything I ought?
Yes, please do.
Thank you, my lord, my ladies. Can I assist you any further?
No, thank you very much. Yes, Mr. Young.
Thank you very much, my lord. I propose, if I may, just very briefly to come back on 3 points.
Yes.
The first is that my letter friend Mr. Siddle took your lordship and your ladyship to section 103A of the Employment Rights Act, which is at the back of the authorities bundle. Could I just do the same very briefly? Your lordship asked me a question this morning as to what was the source or the authority for the objective element of answering the reason for the dismissal question. And I gave an answer this morning that referred to the guidance in Martin and Devonshire and also made reference to subconscious motivation being a potential relevant factor. But if I could just very briefly expand on that by reference to section 103A of the Employment Rights Act. The wording of the statute, of course, is that an employee who is dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or more than one, the principal reason for the dismissal, is that the employee made a protected disclosure. And the point I make is simply that that is a wider definition than it might have been, and it's wider than it would be if it said simply the reason for dismissal is the employee's protected disclosure. Because what the statutory definition as it is includes is the making of the protected disclosure as well as simply the protected disclosure itself. And what I say is that that is the statutory warrant or basis for an objective analysis of whether the conduct relied upon by the respondent is to be treated as part and parcel of making the protected disclosure.
Not sure I understand the distinction.
Well,
if it had said the reason is the employee's protected disclosure, disclosure involves making a disclosure. So I think it's just a verbal difference.
Well, my lord, my response to that would be that in the context of the Act, in which you have some very detailed rules which have already been referred to as to what amounts to a protected disclosure, the fact that the section refers to the making of the protected disclosure does, in my submission, widen it compared to how it would be. But in any event, you have my submission on that.
Yes.
The second point is briefly in relation to the extent to which, it's in relation to ground one, the extent to which one can read across conclusions in relation to Miss Harding. And the point that I make is to pick up on a question that my Lady Justice Simler asked my learned friend, Mr. Siddle, earlier, in relation to the fact that the finding in paragraph 215E that protected disclosure 4 inevitably included some implicit criticism of Miss Harding. And my submission is that the fact that the protected disclosure implicitly and inevitably involved some criticism of Ms. Harding would be the same whoever is considering that, or indeed to whomever the disclosure was made. So if the claimant had made protected disclosure 4 to Mr. Mohammed, then it would still inevitably, implicitly involve criticism of Ms. Harding, and therefore it doesn't.
Well, I suppose that's logically right, but the point Mr. Siddle was emphasising was a slightly different one. That although it may well be, not perhaps in every case, but in many cases, a criticism of an individual, a protected disclosure will involve a criticism of an individual, whether the person to whom it is made or someone else.
Yes.
There's no need to spell it out. So, to take an extreme case, I'm not for a moment suggesting that this is actually what she had said. Suppose she had said, I'm concerned that this template doesn't appreciate the difference that we're no longer dealing with bank-to-bank transactions. And I'm bound to say, I think it's extraordinary that someone in your position didn't even realise that basic point. What kind of a lawyer do you think you are? I suppose you said that.
Yes.
That would clearly be something you didn't need to say, and would be different from, in terms of characterising the conduct, merely pointing out something which actually probably any competent lawyer should have known.
Yes, my lord. But the problem, in my respectful submission, that the respondent has with that argument is that the tribunal found not only that, I'm looking at paragraph 215e, not only that the making of PD4 by the claimant in and of itself entailed implicit questioning of Ms. Harding's legal awareness, but it found earlier that the professional awareness point that the claimant raised was, we find, inseparable in this case from the protected disclosure itself. So the tribunal didn't simply find that it was an implicit part of the protected disclosure. They found that the extra bit that the claimant said, i.e. expressly making that criticism, was inseparable in this case. And the reason I started by saying that the question of whether or not it's implicit in the protected disclosure will be the same to whomever it's made.
But it won't necessarily, will it? Because the tribunal also find that none of them looked in any way, as is 229, what had led up to the incident or the underlying issues that were concerned as the claims in a protected disclosure. So, whereas from Ms. Harding's point of view, the disclosure inevitably, expressly and by implication, involved criticism of her legal awareness. I don't think it follows, as a matter of logic, that from the point of view of those who dismissed, given the findings in 229, it was inevitable from their point of view.
Well, Melody, I think you already have my submissions on,
Yeah.
on paragraph 229, which are essentially that the tribunal in paragraph 229 were contrasting the finding in paragraph 226 that conduct was the principal reason for dismissal, and saying, just to make sure that that is clear, it wasn't the protected disclosure, but they seem to have assumed the separability, in my submission, without having done the analysis that would enable them to come to that conclusion. In any event, the final point that I was going to respond to was in relation to Melina Mr. Siddle's suggestion that fairly and sensibly was the best guidance that could be given in terms of the separability principle, and merely to observe that the respondent's submissions proceed on the basis that the separability principle is something that exists, and that there will be conduct in some cases that is not properly separable from the protected disclosures. But Melina Mr. Siddle made the submission that the best guidance was, can the tribunal fairly and sensibly say that it is separable? the issue that I would respectfully take with that is, by what criteria is the tribunal to judge fairly and sensibly whether the conduct can be treated as separable? And I would respectfully submit that the guidance that has already been given in Martin and Devonshire's, in particular, that the conduct, if it's relied on, must be more than ordinary unreasonableness. In my respectful submission, that is the right criteria by which to judge whether conduct is properly separable from protected disclosures. Unless I can be of any further assistance to
No, you feel you're in your preemptive strike on Fessett. You said all you wanted to say, did you?
Yes, thank you very much.
Either of my ladies have any points? Well, thank you very much. We will be reserving our decision. In due course, draft judgments will be circulated to council so that they can prepare submissions on any, so they can start again, so they can seek to agree any consequential matters, and if they can't, provide short written submissions on paper on any points of dispute, which we will hope to be able to resolve before the hand down. Also, of course, to draw our attention to any typographical or other minor factual errors. May I emphasise that those, together with any necessary preparation for a response to the judgment, are the only purposes for which the judgment is circulated, and it should not be circulated to anyone who does not need to see it for those purposes. If anyone is in any doubt, they should read the judgment of this court in Council General and Wales. And disclosure beyond what is permitted may be a contempt of court. Thank you. It just remains to say thank you to Council for excellent submissions, and to those behind them for their contribution to those submissions, and as I've already said, to the bundles. Thank you.